look at McDonald's. That stock is down. Actually, that's dead flat, let's be honest. We've got an opinion from the National Labor Relations Board's General Counsel. Here's the opinion. McDonald's and its franchisees are now jointly liable for labor and wage violations. Previously, disgruntled employees could only go after the little guys, the franchisees. This ruling extends liability. Now they can go after the deep pockets of McDonald's, the corporation. All right. Judge Andrew Napolitano is here. First of all, look, I'm going to express the opinion. This is a politicized ruling here. It's not a ruling, I know. It's a recommendation. It's opinion. It's going after McDonald's just like they used to go after Walmart.
Well, it is written by people who share the president's mindset that the purpose of the NLRB is to be an instrument to expand the rights of labor unions. There's no question about that. And in fairness to the president, when the president is a Republican, the NLRB's mission is usually to expand the domain of management. It goes back and forth. It is not the neutral party that FDR claimed it would be when they started the NLRB.
Okay.
Nevertheless, this is an opinion from General Counsel who conducts an investigation. There are 181 complaints filed against McDonald's by individual McDonald's employees of the franchisees, not the mothership. You go to a McDonald's, you buy a hamburger. That place is not owned by McDonald's. It's owned by a company that has a relationship with McDonald's. So the 181 of these employees file labor complaints against the mothership, McDonald's. And the General Counsel of the NLRB says 61 of them are valid, 68 of them are not, and the rest we haven't gotten to. The ones that are valid, here's the conclusion he came to. McDonald's, the mothership, exercises such control over the franchisees that they should all be characterized as one big corporation. And therefore, the mothership, which is huge, as you know, can be liable for, can be sued and can be liable for labor violations.
Will this apply to in other situations where it's a franchise operation? Does that apply elsewhere as well?
Well, first of all, this is just the opinion of the lawyer. So when McDonald's challenges this, then there's a trial before an administrative law judge. That administrative law judge issues a ruling, and then there's an appeal to the NLRB itself, and then they issue a ruling, and then there's an appeal to the United States District Court for the District of Columbia. So this is going to tell there are many, many steps before these labor unions can claim victory on
what
this.
What it does is shows where the NLRB under President Obama is coming from.
Precisely. That's exactly what it does, and it gives union organizers great cause for hope. It will also, my dear Stuart, be a full employment act for plaintiffs' lawyers. Exactly. Who will come out of the woodwork to file these complaints against the mothership in Chicago for something that happened at McDonald's in South Carolina. I'm just making up South Carolina. It could be anywhere.
And these are the lawyers who contributed mightily to the Democrats. One quick second here. You're writing on this.
You scratch my back, I'll
the whole
scratch
point
yours.
of this franchise and franchisee model is to give entrepreneurs an opportunity to run a small business. They rent the brand and the best practices from McDonald's Central. So what is this going to do? If it raises the legal costs of McDonald's corporate, it's going to force them to charge more, not just to their customers, to the owners of the businesses. This is incredibly damaging. You're talking about hotels, all kinds of businesses are franchise businesses. And by the way, I might add, this isn't just the NLRB. The Department of Labor now has a guy named David Weil, who is running the wage and hour division. He's a Boston University academic. He has made his name on defaming franchises. Look him up, David Weil, W-E-I-L. This is not confined to the NLRB. This is a coordinated effort against franchises.
To give the two of you and people watching us now more sleepless nights, if this comes to pass, it is but the tip of the iceberg. I mean, there are entrepreneurs all over the country who are franchisees of other entities that the NLRB will begin to look at and try and say, this is really one big corporation. And everybody's costs go up.
Janitorial services, home builders, hotels, restaurants.
Something that probably won't go up, union dues. They want to make it easy.
Are you a lawyer? You were originally a lawyer, weren't you?
I am still a lawyer, but I am very, very skeptical of the plaintiff's lawyer mentality, as are you. I don't think I am as skeptical as you, but very, very skeptical. And the other day, I mean, I revealed here on your show that I was reversed by the appellate courts very frequently when I threw these cases out because I felt under the law they were frivolous.
Is that why you're not a judge anymore?
Oh, God.
Don't get into that.
You guys appeal me so much. You see the balcony in my courtroom? You might as well put 3 judges, appellate judges in that balcony, and they can go like this every time I make a decision.
I'm waiting for a Republican administration that says we are gung-ho for tort reform, big time, state by state, case by case.
May I suggest that you not hold your breath?
No, I agree with you. I agree with you. Lawyers.
Because those plaintiffs' lawyers contribute on both sides of the aisle.
My lawyer is watching this program as we speak.
Right.
Lawyers. Thank you very much, Judge. Another good one.
Nice to be on.
All right, thanks, man.